We have a very distinguished panel lined up for us, which will be led by Alex Talon on the topic, where are we going and where will we stop with AI? Floor is yours.
Thank you, Simone, and hello everyone. I'm very happy that I can moderate such an interesting and excited panel discussion about lawyers and AI. Where are we going? That perhaps we know, but where we will stop, I don't think that we know that really. Now the question is, must we be afraid of AI? And a couple of years ago, I think somebody answered on that question saying, I'm not afraid of the presence of artificial intelligence. I'm afraid of the absence of real intelligence. And I think that perhaps AI can also help lawyers to be more intelligent than they already are. But I know that in this room, of course, we are all intelligent people, but also intelligent people can, I suppose, also use AI. So I would also like to welcome our speakers. And as for the previous panel, we have also here wonderful speakers today. And I am very delighted first to welcome the first speaker of this panel is Maria Dymitruk. Maria is an attorney at law and researcher specializing in artificial intelligence and law. Since 2014, Maria has conducted research at the University of Wrocław on the application of AI in legal context, e-justice, and the broader impact of technology on the justice system and legal professions. She earned her PhD in law with distinction, defending a doctoral thesis on the admissibility of AI use in civil proceedings. She represents also the Polish National Bar of Attorneys at Law in the work of the CCBE, serving as a member of the Committee on the Future of the Legal Profession and Legal Services, as well as the Surveillance Working Group. She worked on projects at the intersection of AI and law, including legislative initiative in collaboration with the Polish Ministry of Justice and the Ministry of Digital Affairs. Maria combines also her academic and professional careers by leading the AI practice at Lubas and Partners law firm. She has an extensive portfolio of scientific professional publications in the field of artificial intelligence, along with broad research experience. So, Maria, I am delighted to give you the floor.
Thank you very much, and thank you very much for this kind description of myself. Could I ask the presentation to be shown full screen? It's like Control F, probably, or Control L. It's PDF, so Control L from large. Okay, great. Thank you very much. I'm really privileged to having a chance to speak to you. And let me share how I started the presentation, or the preparation for the presentation. I asked Peter, what do you want me to say to the audience? And he said, please, Maria, be informative, share some do and don'ts, and please share what bar associations should do with all this AI hype. I'm calling it hype because it is hype. So that was the structure for my speech to you today. I would like to share as many practical and as many personal examples as I can, because this is the only way, way of going into details, and the devil is in details rather than some general values and general approaches, as we all share the very same approach about ethical use of AI, in line with European values, in line with confidentiality rules, and so on and so forth. But I would like to step down a little bit and show it on examples. And I was greatly presented my bio by our dear moderator, but let me share the three perspectives, the three angles that I'm looking, from which I'm looking at the topic of the use of AI by lawyers. My first experiences with this topic was from academia side, and I'm still observing what researchers in this field do, and the effort is great. They started many years ago, like 50 years ago. They started to go into symbolic and sub-symbolic approaches to AI. Professor Francesconi will tell you more in a second. But my observation now is that there is a little bridge between scientific community that devotes their work to AI and law and the practical side of what we do every day. The second thing is that I have tested multiple AI solutions that are available on the market, or they are tested by the vendors to be introduced to the market. And I am disappointed with each of these tools. It's not an accusation against the technology. It's rather an information that you need to keep in mind when I will be delivering some examples, because the legal tech providers are a different level of maturity, I would say, because I have spoken with countless of startups that they thought that it is as simple as that I take the large language model from OpenAI or Gemini, fine-tune it on the database that is available on the internet even. We have this great discussion during previous panel about the accessibility of public data, the accessibility of court decision in the internet. So obviously I can take it, I can scrap it, or I can use it through API, and then it is, in their opinion, as simple as that I combine it and the result is great. The result won't be great. And what is more important in terms of the providers that we have access to is that those very big legal information providers like Westlaw, LexisNexis, Wolters Kluwer, and so on and so forth, they are slow. I am daring to say that because they are slow, and what is more important, they are still, and that's the fact that is very at the core of our profession, they are jurisdiction-based. So for me, from the perspective of a Polish lawyer, it doesn't matter whether in Portugal or in France there is some legal tech solution. It is just not available for me. It is not suited for me. So we are very limited when it comes to the actual solutions. Very limited. And I'm daring to say that because obviously there is a great hype. Everybody is speaking about the implementation. Everybody is speaking how much time or effort can be reduced thanks to the use of these solutions. And then the perspective I'd like to focus on today is the perspective of an average lawyer. I am considering myself as an average lawyer, so I am not representing big law firm corporations that are capable of affording a large-scale, tailor-made AI solution trained on my data, my previous contract 10 years back or something. It costs like hundreds of thousands of euros. So the cost is unreachable for the most European lawyers, which are mostly SMEs. Generally, European companies are SMEs, and we are no different here. So just to mention one thing, even those big corporations, when they are rich enough to implement some tailored AI solution, enterprise class solutions, do you know how high is the success rate in terms of implementation generally in business of such enterprise class AI solutions? 5%. 95%, according to MIT research, of the implementation efforts is wasted. So you can see the cost of this and the result of the actual implementation efforts. So what's the result? The result is that obviously on the market there are available solutions that are tailored to legal purposes. I will skip going into details how much generative AI tools, because we are speaking about these tools, can be actually used. I believe Professor Francesconi will greatly discuss it from a scientific point of view. So the situation in which we end up is that most of the lawyers just use these common chatbots available everywhere. ChatGPT, Gemini, Copilot, Perplexity, Claude, any other. That's the fact. I will share with you some research result that I was personally involved. It's a global report on the use of AI in legal practice. It was conducted by not only me, but a few scientists. And there was first report back in 2023, and now we are going to publish the second report based on the data from this year and previous year. What is the result? Obviously, something that is quite common, that over 80% of lawyers started to use AI. In most cases, these were commonly available chatbots like ChatGPT, not tailored solutions, and we use it every day. It is no different from the perspective of general results, as when it comes to this MIT research that I mentioned with 5% success rate in implementation. In case of those general chatbots, the success rate is much higher, 40%, but there is huge difference between this 40% and the actual use of the generative AI tools by employees, because the actual use is 90%. So you've got 50% of a gap between something that was implemented, well thought out, I hope, followed by some kind of a policy or rules how to use, and this 90% of employees just using ChatGPT for different tasks. And our research confirmed that the situation is more or less the same in our profession. The difference is that this AI shadow, so this gap between 40 and 90, is smaller. We have checked whether lawyers are supported by some kind of rules, internal rules within law firms or legal departments, because the research is also devoted to in-house lawyers, whether they follow some internal rules. And they don't in case of almost 30%. So only 30% of law firms didn't establish some kind of rules for lawyers how to use those LLM solutions. And this is much better than in other cases, because in other cases it was 50%. We are more secure. It's a good signal, but the question is whether it has protected us from something. Obviously it was not, because this is just few examples, one from each year, of some lawyers somewhere in the world using, in all the cases, ChatGPT for the purposes that he or she should never do. The first very famous one from New York, and Mr. Schwartz using ChatGPT, but then we have multiple of examples. In our jurisdictions as well. This was just an outbreak. Now we are in the phase that everybody, lawyers, our clients, parties that are non-represented by lawyers, judges, everybody, every person that is within the circle of judicial proceedings uses ChatGPT. In order to show you that this is not only reckless approach of lawyers to use ChatGPT, because these are only 3 examples of lawyers misusing ChatGPT. 2 weeks ago, I spoken with my friend who was she was delivering a workshop to Polish judges. And one of the Polish judges said, "Oh, I use ChatGPT for producing justification, so the reasoning part of the decision." Great example. What do you use it? Which tool do you use it? ChatGPT. And she was, okay, do you use the actual data of the parties to the proceedings and everything? Yes, I do, obviously. Otherwise, it would be pointless, as anonymization process that I would need to do would be just time-consuming. Okay, but you are aware that you shouldn't do that. No, obviously I'm aware of the fact that, we need to be secure with the data, but I am using ChatGPT Enterprise. Come on, that should be the answer. What's the difference? The court data already was transferred to OpenAI outside of Europe with no anonymization involved, taking into account what we discussed during the previous panel. So now everybody's using it. So we are trying to catch up. Judicial systems are trying to catch up. The great example is Brazil, in which the scope of the claims that reach courts are unimaginable in Europe. So they've implemented few hundred of AI solutions to speed it up. And the result was that, the average time of the resolution of the case is getting higher and higher every year. But what is also getting higher every year is the amount of the claims reaching the court, because parties and lawyers now are using ChatGPT or any other court just to produce more and more documents. And the result is, you see it on the screen. It was an example presented by the director of Wolters Kluwer Poland at the conference this week, that we are going up, and they are going up and that, and it will never stop. And that's the true disruptive effect of generative AI to the legal profession, not the one that we are speaking with some charlatan is speaking what you can do with his AI tool. So where it is heading, where it will stop, whether it will stop, it won't. And that's the thing. And I will ask Peter to present some do's and don'ts. So on the screen you see 3 of them. What you should do: automate routine tasks, verify output, and be bold. AI is to revolutionize legal practice. I would like to see your hands up or down. Whether do you agree with these do's? Who agree? Okay. Who disagree? No one. So majority of you agree. Good. Good. Perfect. Now I will dare to disagree. In a non-obvious way, but let me share a broader perspective. As I said, the devil is in details. So the first hint that is given to lawyers during those conferences, workshops, and everything is automate routine tasks. Please focus on the main task, and what is actually a burden, please automate. I even heard once a rule that if you roll your eye because of some task, please automate it. You will no longer roll your eyes. Do you know when I roll my eye? When I need to review the 100 IT contracts. Should I automate it? Thanks to the generative AI tools? This is the core of our profession. This is the place where I should be, not automation. And going to the second do's, verified output. Okay, so let me take this statement. Okay, you can use AI, but then, for example, in reviewing IT contract, which is my everyday work, and they verify the output. I won't. Do you know why? Because how our brain works. I will share with you this very famous MIT study scanning our brains on the task when you do something without the use of ChatGPT and with the use of ChatGPT. Sorry for saying only the example of ChatGPT, but it is more or less very the same with any other tool. So there are less neural engagements in the process in which we have some support from LLM. It is as simple as that. We limit our cognitive capabilities because of the use of it. Let me share an exact example. When I reviewed the contract with the use of generative AI tool once, the result was great. Second time, third time, 10th time, 100th time. At what point I will stop verifying and just take it for granted? I will, because our brains work the way that we limit the calories we need to burn during thinking processes. It is not something that we are aware. It is how the biology works. This is the way that mankind survived during the centuries, the thousands of years. And we need to take into account. So at some point of time, we will stop verified output. And let me share with you what is my response to this. I use those tools not to support me, not to give me hints that I can follow or not based on the verification process. I use it for assessment of the result of my work, to find those gaps that I missed, to find the places in which my thinking process should follow. And that's the only way of overstepping the risk that I was discussed. And the third sentence, be bold. Hey, I will revolutionize legal practice. The tricky part is be bold. Because be bold end up in this outbreak of hallucinations in legal proceedings. Don't be bold. Don't be bold. Those legal providers shouldn't be bold as well. They should be aware of the limits. They should be aware that large language models are used to predict the next token in a sentence of tokens, and next word in a sentence. As simple as that. Hallucination is not a flaw. It is just characteristics of how these models work. To share another example, today I saw the statement of Law Society of Ireland saying that there was some situation in which AI overview in Google misinformed about the number of disciplinary proceedings among Irish lawyers. It was obvious hallucination. So they've approached Google and they gave statement. Should they, shouldn't they? It's a characteristic. I will say it once more. It's a characteristic of the large language models that they hallucinate. They are supposed to do so. So these do's are rather don'ts, and okay, I will leave with your thoughts about it, because I would like you to disagree, because I am discussing with many people, and the different angles, the different perspective are, helping me to understand those issues better. So now the third task, the role of bar associations, which is the main task that we should do. Obviously, it can be easily answered. Please train your lawyers. Education is key, and then try to be as supportive as possible, but be aware of the limits. Yeah, it's not as simple as that. I am struggling from my perspective. I am also the president of the New Technology Commission, so this is my job, to show the way in which bar association should do something. So the first thing is what I called ethical and regulatory guidelines. We need to go beyond this very vague and broad rules, like, for example, be transparent. What does it mean? What does it mean in terms of our ethical internal national rules, even the legislative acts that we operate within, delivering legal services in our jurisdiction? Because it can be understood in 1,000 ways. It is not informative for our members. What does it mean? Okay, I need to speed up a little bit. When it comes to education and training, obviously, please train and please educate. But the key is, who is delivering the trainings? Who is delivering education? I have attended multiple conferences which were not informative. We need to go deeper into that. Monitoring AI developments and support for members. This is the key, because normally every lawyer should now devote 1 hour of their daily work just to get through all those legal tech vendors, test everything, verify, check terms and conditions, then test whether it is useful or not, and at the end buy something or decide not to buy something. Our members do not have time for it. We should do it for them. We should test. We should guide them. We should even say which provider is better than other. It is risky, because we will speak about exact vendors. It is risky, but I don't see any other solution. Thank you very much for your attention.
Thank you very much, Maria, for this, yes, also a challenging presentation and proving that perhaps AI is not making us necessarily smarter, but that we must use this tool carefully also. And so that brings me also with our next speaker, who will give perhaps another approach on this, because he is not a lawyer, he is a scientific. And Professor Enrico Francesconi, that I'm very happy to welcome, is a research director and since March 25, director of the Institute for Legal Informatics and Judicial Studies of the International Research Council of Italy. But it's interesting to know that he was also president of the International Association for Artificial Intelligence and Law and has been a policy officer at the European Commission and European Parliament, where we are today. He's a section editor on ontology and knowledge representation of the Artificial Intelligence and Law Journal and co-editor-in-chief of the Journal on Open Access to Law and at the Cornell University Law School. He is program chair of the next International Conference on Artificial Intelligence and Law at Singapore Management University, and his main research interests include artificial intelligence and law, semantic web technologies for the legal domain, machine learning and natural language processing for legal knowledge, classification and acquisition. So, Enrico, it's up to you.
Thank you very much, Alex, and thanks very much to the CCBE for their kind invitation. It's an honor to be here with you. As Alex said, basically I will have not a legal perspective but a more technical perspective about the status and evolutions of AI in the law domain. Because actually there is no doubt that the information technology environment is characterized by keywords like semantic web, smart data, natural language processing, machine learning, and in particular in the legal domain, e-law, e-justice, and overall artificial intelligence. So it's important to see why there is this particular relation related to the artificial intelligence with the law domain. Actually, the law is made of rules and interprets and creates facts. And this is something that also an artificial intelligence system does, so the so-called Turing machine that processes facts through rules. And it does it according to two different paradigms, the symbolic paradigm and the sub-symbolic paradigm. In the symbolic paradigm, basically, rules are expressed by symbols with a clear semantics. And AI systems are basically a collection of rules and algorithms. And typically, success stories in these fields are the expert systems, for example, or the sub-symbolic paradigm or connectionist models, where rules are considered as a combination of elementary processing structures. And the paradigm is very different. It's learning by examples, and the success stories in this area is basically the development of neural networks. So it's important to know why we passed from the 90s to the current scenario, from the so-called AI winter to the current hype. So basically the AI winter is a period of disillusion with respect to the results of AI systems. And we are achieving now a particular period of a hype in the AI systems. And many scholars consider that the reason is due for the relation between AI and knowledge. In fact, there is a claim, typically in the literature, that intelligence requires knowledge. And probably the AI winter was due to the lack of knowledge to be processed by AI systems. The problem is that knowledge is voluminous. It's hard to characterize accurately. It's constantly changing, and it requires a semantic organization, because knowledge is basically made of data and their semantics. But in the early 90s, the AI meets the web, and this changed completely the scenario of reference. In fact, and this represented the conclusion of the so-called AI winter. In fact, the web is nothing but a universal repository of knowledge in digital format for the development of AI systems. So this data can be used to train AI systems. And moreover, Internet and the web need advanced application for managing data. So we had actually a virtuous combination between AI and the web. And from that time on, the evolution of AI has followed the evolution of the web. So now a question that can be posed is how has evolved the web in the last few years, in particular from the web 1.0 to the web 3.0. So in the first era of the web, we have what was called Web 1.0 or static web, a web characterized by static information with limited interaction with the users. And in the mid-2000, we had the so-called Web 2.0 or social web, and success stories in this respect were actually the social networks, because we had the possibility of sharing content and implementing collaborative content creation systems. Another success story, for example, is Wikipedia. And currently, we are in the era of the so-called Web 3.0, also known as a semantic web, or in the literature sometimes it is called Web of Data or Internet of Things. But what is in particular the Web 3.0? It's the process of embedding in the World Wide Web information that is not only understandable by humans, but also understandable and processable by machines. And to do that, we have to adhere to a particular set of standards in order to prepare the data and to expose the data in the web, and in particular in the semantic web. The objectives of this process is the technological, semantic, multilingual interoperability between information systems in order to have advanced services for the end users, like, for example, advanced search and retrieval facilities, and moreover having the possibility to implement reasoning facilities, automatic reasoning facilities. From that time on, we faced a phenomenon of explosion, let's say exploded phenomenon of having data on the web on a massive scale. Data in the semantic web are usually called linked data or linked open data if they are free of a particular license. And this is a picture of from 2007, centered on of the linked open data cloud, centered on DBpedia, which is the semantic web version of Wikipedia. And from that time on, the phenomenon has exploded. And this is a picture of 2014, and this is the 2025. So coming back to the beginning of my presentation related to the claim of that the intelligence requires knowledge, actually knowledge is data and semantics, so characterized by particular semantics in terms of, for example, of metadata. The knowledge is actually on the web, and the knowledge is actually in the semantic web in particular. So that we can say that the semantic web is an important infrastructure for AI systems, because it provides the languages for knowledge representation and reasoning. So the typical examples are legal reasoning, for example, coming from premises to conclusions. And moreover, to have, let's say, smart data for intelligent systems to train machine machine learning systems, natural language processing, and the latest incarnation of AI system, the so-called large language models. The European institutions are well aware of this phenomenon. In fact, in the AI Continent Action Plan of the April 2025, there is a particular point related to the development of services related to high-quality data, which is an important aspect to provide to the users, but also to the other kind of players, like economic players, for the development of AI systems. And in fact, the European Commission, in particular, has worked a lot in the last few years to create the open data cloud centered on EU law, which is actually behind the services like EURLEX or behind other services like the European Data Portal. Also, the European Parliament recently launched its own open data portal that you can find at this address, and this is the actual homepage of the portal itself. Basically, this is actually an important mandate of the European institutions. They are owner of public data, and it's important that they provide services to the market, for example, but also to the end users, in order to provide high-quality data that can be used not only for search and retrieval services, but also to train AI systems. And this is an important part also for the implementation of the latest incarnation of AI tools, the so-called generative AI, or also known as large language models. As Maria Dymitruk said previously, large language models are nothing but algorithm for automatic generation of various type of content from, let's say, a probabilistic perspective. They can provide services in terms of creation of text, images, audio, synthetic data, so to develop the pre-trained connectionist models on large quantities of data that are actually available on the web, as I said before. Examples are BERT of Google or GPT, or at the ground of ChatGPT and so on. But this kind of systems have, let's say, an impressive behavior, but also offers opportunities and also pose some risks. Opportunities are in the sense of the creation of new content, but the risks, as Maria said before, are a particular distorting phenomenon, has hallucinations or psychophancies. So hallucinations are the content creation not based on objective reality, actually, because this is, as was said before, it's a particular characteristics of these systems. They are not, let's say, a problem of them. They are actually a characteristic of this system, and we have to be aware of them. Moreover, another phenomenon recently revealed are the so-called psychophancies. So the fact that content, the creation of content generation, overly flattering towards the user. So the tendency to agree too much on what the user are looking for. We said yesterday at dinner, they are, let's say, kind systems, but untrustable in the most part of the time, sometimes, I would say. Hallucinations are at the basis of deep fakes in generative AI. So the combination of term deep learning and fake So they are basically the generation of video or audio that look persuasive, but they are fake. So they basically show people who do things or say something not done or said, and this is actually a risk in using this kind of systems. And psychophancies in generative AI are also another risk because they can cause the dissemination of misinformation. They can reinforce negative or impulsive emotions. There are particular risks of encouraging unsafe behavior, and they prevent the debate between people and the debate, the discussion of differing opinions. So in order to, let's say, fill the gap.
Sorry.
I have basically finished. To fill the gap between and to overcome the risks that, for example, generative AI used to pose, in the literature we are looking to the so-called neurosymbolic approach to AI, which aims to fill the gap between symbolic and sub-symbolic approaches. Symbolic approaches have the benefit of transparency, but they suffer from the knowledge acquisition bottleneck. On the other hand, sub-symbolic approaches have the problem of scalability, have the benefit of scalability, but they lack correctness guarantees. And especially in the legal domain, we have basically the need of explainable AI, so the explainability of AI predictions. Which is the impact of AI in the legal profession? It is expected that in 5 years, 1-3 humans will work along with AI systems doing the work that would require 10-20 lawyers, because especially in the field of producing summaries of applicable laws, in draft contracts, in providing consultancy service on specific cases like predictive justice. And it is estimated that, for example, in the US, we will have a decrease of 25% of lawyers. So it's important that lawyers will be acquainted of using AI systems, especially in the generative AI. So what's next in 10 years? AI probably will follow the evolution of the web, the so-called Web 4.0 or symbiotic web, where not only human and computer will interact, but also computer and computer will interact one to the other, so that we will have in the Web 4.0 intelligent agents for legal data mining and e-discovery, and the possibility for having an automatic judge, knowing the profile of the people and the knowledge of the rules in order to take decision on legal disputes. But what's next? Nowadays, the web is emotionally neutral. In the next future, we will have the so-called emotional web, where emotional aspect of humans will be considered as processable data. And we know very well how, in the legal domain, this aspect is very sensitive. So what's going on? It will be a matter of quantum computing, for example. We actually don't know, but it's important to ask to ourselves, in the Web 5.0, where emotional aspect will be processable data, how will you persuade, as a lawyer, a digital judge? And with these questions, I leave you the floor to the others. Thank you very much.
Thank you, Enrico, for this very interesting presentation, and that's also, of course, opening our mind and giving what the possibilities are of this artificial intelligence tools. And this is also a link, of course, to the next speaker now, who will give us the approach of a bar official about the impact of AI on the profession. And so I'm very pleased to welcome Jeroen Soeteman, who is President of the Netherlands Bar, the NOVA, since the 1st of September 2024. together with Sanne van Oers, who was also present there, and who is, as you know, the head of the Netherlands delegation. As a bar president, Jeroen's primary focus areas are the role of the legal profession in the rule of law and the protection of confidentiality. He has been a criminal lawyer since 1999 and currently practices at Jeroen Soeteman advocaten in Amsterdam. Jeroen is also a guest lecturer in legal tech and the legal profession at Erasmus University Rotterdam. Previously, Jeroen worked at CMS and Corvinus Advocaten, and from 2016 till 21, Jeroen served as a chairman of the Dutch Association of Defense Counsel. So, Jeroen, I give you the floor.
Thank you very much. In the early of the 20th century, there was a profession known as the knock-upper, and you'll see a picture of her on the screen. It was someone to wake up people by tapping on their windows, or when their window was higher, shooting little dried peas against their windows. And like the dinosaurs, also the knock-upper became extinct. Not due to force of nature, but to force of technology. Because when alarm clocks became more reliable, this profession was made obsolete. And how do we do it now? I have my alarm clock here. And in the weekend, I can set it and it wakes me up when it tells me I slept enough and deep enough. So no time needed anymore. And today I ask you, as lawyers, are we facing a similar tipping point? And is the human lawyer becoming the knock-upper of the 21st century as digitalization and AI fundamentally transform our profession? My name, as said, is Jeroen Soeteman, and I'll be talking on behalf of the Netherlands Bar what we are doing and how we are looking at this new development, and to see the risks on the one hand, the opportunities on the other hand. And just as technology once changed daily life, it is now reshaping the legal profession and the legal world. I witness, as the President, the changes every day. And to guide the legal profession, at the Netherlands Bar, we established a working group. A working group bringing together experts to monitor developments, advise on policy, and develop practical tools for responsible innovation. And over the past year, our working group has focused on 4 core themes. The responsible use of technology, also meaning digital resilience. Secondly, the inclusive digital transformation, because we think we need an equal level playing field on the data and the digital means for all lawyers. And we need open access AI, because our small firms, our average lawyer, as Maria stated, need as much possibilities to use it as the big firms. The third one is knowledge and skills. And the fourth, innovation in legal services. Because it is not only using new technology, it is also developing a new way to think and to work. It needs a fundamental change in the mindset and behavior of the lawyers. And our mission is to ensure that AI will strengthen and not undermine our core professional values. These core values are set out in the Dutch Advocates Act, and they are independence, integrity, confidentiality, competence, and loyalty to the client. And we pay special attention to small firms and solo practitioners who may be more vulnerable, not only to technological challenges, but also to ethical challenges. And the project group works closely with partners in the justice system and actively promotes knowledge sharing and dialogue within the profession. I see that our collective challenge is to embrace these changes with a conscience focused on our core values, ensuring that innovation serves justice and society as a whole and serves the client in its individual case. Now, let us reflect more deeply in the role of the lawyer in our legal system and in society at large. Lawyers are no more merely service providers or technical experts. We are, first and foremost, guardians of the rule of law. Our profession is built on a foundation of trust. Trust from our clients, trust from the courts, and trust from society. This trust is earned and maintained because we uphold the before-mentioned core values. And they are not abstract ideas. They are the pillars that support our entire justice system. And this rule of law depends on lawyers who are willing and able to stand up for the rights of the individuals, to challenge injustice, and to ensure that everyone, regardless of background or means, has access to justice. We advise our clients, we represent them in legal proceedings, and we provide guidance in moments of uncertainty and conflict. And in doing so, we help to ensure that laws are applied fairly and that the rights and freedoms of all are protected. But our role does go beyond technical legal work. I think the human dimension is irreplaceable. Listening carefully to a client, analyzing complex situations, asking the right questions, and making difficult ethical choices. These are skills where Enrico just said it will be the Web 5.0, but where I say no algorithm can replace it. All lawyers know that sometimes just listening and not responding to a story of a client, or, for the people who can do so, raise only one eyebrow, can make a client suddenly tell a whole new story about what really happened, and that is necessary to do our job. And that silence and that eyebrow is not something AI will be able to do for various reasons. Empathy, moral judgment, and the courage to challenge both clients and authorities when necessary are essential qualities of the lawyer. And these soft skills are what allows us to see the person behind the case, to understand the context, and to advocate, not just for the letter of the law, but for justice itself. And as technology advances, these human qualities become even more important. AI can, of course, process data and suggest solutions, but it cannot always understand nuance, context, or the emotional realities of a client's situation. It cannot weigh competing interests with compassion or adapt to the unpredictable nature of the human conflict. The lawyer's ability to combine legal expertise with ethical reflection and personal engagement is what makes our profession indispensable to the rule of law. And moreover, the lawyers play a crucial role in safeguarding the integrity of the justice system itself. We are often the first in the line of defense against abuses of power, procedural shortcuts, or the erosion of fundamental rights. On a side note, yesterday, I'll have it here in front of me, the Court of Amsterdam ruled that Meta Ireland, being the owner of Facebook and Instagram, must ensure within 2 weeks that they offer a direct and easily accessible option for a timeline that is not based on profiling. It's a big case in the Netherlands and a big win for an organization called Bigs of Freedom, because Meta gives the option formally to choose between a chronicle timeline or a profile timeline, which is an obligation to offer that. But every time you close the app, it sets back into the profile timeline, which for them is the more money-making part of it. And in a ruling yesterday, the Court of Amsterdam ruled that that is a breach of the Digital Services Act. And within 2 weeks, Meta Ireland needs to rebuild the way to offer this to only, of course, in the Netherlands, the people using it. It is by procedures like these that lawyers can make a difference. And of course, there were also lawyers on the other side, don't get me wrong. But organizations need lawyers for that. The role of the lawyer in the rule of law is a privilege and a responsibility. We are called not only to serve our clients, but to serve justice and society as a whole. And as we embrace AI, let us do so with a renewed commitment to these values and to the essential human dimension of our work. And of course, we look at the future. And we must recognize that technology is not an abstract force. It is reshaping our daily practice and daily life. And that brings the practical realities of AI in the legal profession, the opportunities, the risks, and the challenges. It offers tremendous opportunities, AI. automating routine tasks. Some people might say it's a good thing, others say that it's not. Do data analysis and support decision making. And of course, the bigger firms are for years and years working and experimenting with AI, gaining efficiency and new insights. But for the smaller firms and the legal aid lawyers, the challenges are greater. The limited resources can make it harder to keep pace with technological and ethical demands. AI can also improve access to justice, for example, through self-service tools and digital platforms. But there is a risk. If digital skills or resources are lacking, inequality may increase rather than decrease. And our project group stresses the need for an inclusive digital transformation, ensuring that all lawyers, regardless of firm size, can benefit from and contribute to these developments. And if we then look at the core values, I mentioned earlier, there's one message I want to leave with you today. Our core values are not checklists to be a good lawyer. They are the DNA of our profession, and they are more under pressure than ever before. Let's start with the confidentiality. The trust between a lawyer and a client is sacred. They must be able to share everything with us, knowing it will remain private. But with AI, there's a real risk that confidential information should be exposed, most of the times without even the lawyer realizing it. If we use the public AI tool without anonymizing, how do we know where it goes? We experience, as the Netherlands bar, that so many lawyers, not only the small firms, but also the big firms, do not think enough about this so important part of our work, the confidentiality. Thinking they are helping their clients, thinking they're getting a better advice, they use AI in a way that lets the data go forever. And once it's gone, of course, and it will never get back. And I'm afraid that in many years, we'll only find out how much data was found and used at another moment against the same clients we represent. And maybe competence is needed to look at it from a proper way. Because competence means more than legal knowledge. It means nowadays understanding how technology works. What's the limitation of technology, how to verify the output, and how to use it to get a better result. We've seen the hallucinations. We recently had one in the Netherlands as well, a lawyer with a hallucination, and she stated in court when it was found out that it happened when she was putting her Word document into a PDF. I did not know that PDF could do that, but it is the lawyer is named in the media. It is clear that here something went wrong because people do not have the competence to use AI. Competence requires us to be legal experts, but also users and critical users of technology. We must keep learning and keep questioning, not about the law and the jurisprudence, but also about technology. And then independence. Independence is at stake because AI can be a powerful support, but can also be something introducing bias or nudges towards certain outcomes. If we rely too much on the automated tools or on a handful of dominant tech providers, we risk losing our professional objectivity. And independence means not just being free from the client or the government, but also from the technological machines that are helping us out, and algorithms. We must be the one making the final judgment, not the algorithm. And then the integrity and loyalty towards the client. Using AI responsibly means being transparent with clients about when and how we use these tools. And how do we charge them? Lawyers ask us a lot, because it's not an hour-based invoice anymore. If a client would object to the use of AI in a case, we must respect that. We must also be honest about the limitations and risks and never allow efficiency or convenience override our ethical duties. AI will be changing the landscape, but it does not change our fundamental obligations. If anything, it makes them more important. And our duty is to ensure that technology serves justice and not the other way around. Looking ahead, the future lies into collaboration. The lawyer of the future will remain human, but work will alongside AI. A human in the loop is essential for ethical and just decision-making. Continuous education, critical reflection, and interdisciplinary cooperation are vital. The Netherlands Bar and the CCBE both call for practical guidelines, ongoing training, and a culture of responsible innovation. And that innovation must be inclusive. It must never come at the expense of our core values or access to justice. We must ensure that digitalization is inclusive, that all lawyers have the skills and support they need, and that the benefits of AI are shared across the profession. So where do we draw the line? I'll leave you with this final thought. AI is a tool and not a replacement. The line is crossed where AI threatens our core values or our access to justice. If a robot lawyer truly performs better and enhances access to justice, I welcome that development, truly, but always under human control. Let us move forward together. European cooperation is essential, and only together we can safeguard fundamental rights and ensure that the digital transformation of justice systems serve the public good. I'll thank you for your attention, you and the people watching at home. I thank the CCBE and the ELF for this invitation.
Thank you, Jeroen. I find it a very interesting presentation, also a little bit of a conclusion of the three presentations, emphasizing the importance of the lawyer as a human being to provide legal services and not a machine, and I think that is important. So we have not so many time left, and I will open now the discussion for the floor if somebody has a question. I see nobody for the moment, but we have some time left, so, yeah.
Thank you very much. Thank you for the very good presentations, very interesting to hear. I heard twice from Mr. Francesconi and from you, Maria, that hallucination is a characteristic of AI and also psychophancy. And now we see AI applications improving, I would say. If you have asked ChatGPT a year ago, you would have gotten 3 decisions to your question, and all 3 were not existent. When you do that nowadays, those decisions usually exist, or at least a few do. So how does it come? What are possibilities for AI providers to work on those problems that we obviously see? Is there a afterwards treatment of those results of the AI that could solve those problems? Thank you very much.
To answer your question, thank you. This is a very interesting question, and the answer is not easy. Obviously, all the tools, also the major players, are improving their services. But let me share you the conversation that I had last week. A friend of mine approached me with a request to test his solution that it is 100% deprived of hallucination. So it took me just one attempt to prove him wrong. So at the end, without the change of the paradigm behind the architecture of the system, or even large language model versus symbolic AI, we won't change it. When it comes to psychophancy, even the way I shared with you how I interact with those, it is some way of overcoming this issue, but it is just, homemade solution rather than answer to this problem. And I believe that the answer given by Professor Francesconi is a solution. So we need to find another paradigm combining the strength of sub-symbolic approaches, which large language models are the best example of, with symbolic approaches, which are explainable, followable, that can deliver actual reasoning process behind it. And that will be the moment of time in which we can start thinking about no hallucination era.
Yeah. I agree with what Maria said. Actually, I think that one of the possible solutions, according to the current literature, is actually the development of a neurosymbolic approach, which means a combination of the two approaches, the one coming from LLM and the other one more traditional, relying on knowledge representation systems. Because I think that we have to consider what these components used to do better. On the ontologies, so knowledge representation system, you are guaranteed with respect to the formal logic of the legal reasoning, for example. On the other hand, large language models, or in general machine learning, is able to overcome the knowledge acquisition bottleneck. So to provide, let's say, a scalable solution that allows you to deal with a larger amount of data that are constantly changing, as I said in the presentation. So I think that instead of relying on the predictions of a large language model, it's better to exploit them in what they are doing at best. So in dealing with data, a large amount of data, extract knowledge, and relying on ontologies for implementing automatic legal reasoning.
So there is still possibility for one more question. Yes.
Thank you for the very interesting interventions. Peter Amoki, I would like to ask you, do you see any role for bars in trying to convince lawyers in participating more like in research, or in trying to balance the very capital-intensive nature of these artificial intelligence approaches that we see today, in terms of providing data or providing evaluations? So I'm just trying to see what kind of more active roles do you see in the process of trying to push our position forward as lawyers, and not just be passive participants who are just expecting from the market to have solutions, and in the same time, seeing that big law firms have bigger possibilities in this term because they have money to spend these tools.
Thank you for the question. I don't know who is wanting to give an answer. Jeroen?
Yes, I do see a role for the national bars. And I think that a national bar, which leaves it to the market, might need to rethink about its responsibility towards, not that maybe the lawyers, but we have to ensure they are good lawyers, so the people needing them have a proper lawyer, have a good lawyer to represent them. And within our bar, it'll be a change in not only what we do now is informing people, but making it part of the first 3 years of a lawyer to be able to use AI. Because we could think anyone can use it, but we need to make sure they can use it. And furthermore, every year a lawyer needs to do extra study. And one could think of a situation where it's necessary to do so many hours of studying on this topic every year to be able to keep on working as a lawyer. And we need to guard that as the Netherlands bar. We cannot tell the bars or the market will do everything. The market will take up giving lectures, giving courses, but we need to guard the quality of them, because we don't want, as you said, to be at so many congresses which are useless because the people who are there telling us what to do and how to do it are not the correct people. So we see a big responsibility from the younger generation, but also for the oldest generation, because they lack the time behind the computer that the younger generation already had.
We can close now the discussion. It is lunchtime. I see you asked me to thank you as an audience, also the audience online, and especially, of course, I thank the speakers of the three panelists of my panel for their beautiful presentations.